are we jeopardizing a situation where if the international community and the ICTY does not continue to be engaged with the courts, the domestic courts in the region, the former Yugoslavia, that we risk losing this unity of jurisdiction that has come about by a focus on international jurisprudence, international practice. Judge Pekar, you've said that it's far more important that the international community shows its ability to react to the commission of crimes through the exercise of independent and impartial jurisdiction, irrespective of how they might be carried out in relation to what the ICTY has done. And Barbara, getting to this unity of jurisdiction, the U.S. Embassy, or the U.S. government, I think, did what I think it was quite a fascinating approach in Bosnia in the earlier days, is by working with Bosnia to create a common law system, if you will, for these types of prosecutions. We all know that this was a civil law system, and there's no doubt that the U.S. had great influence on the development of this very unique form of judicial system within Bosnia-Herzegovina. And I'm curious whether that was part of the focus of creating this unity of jurisdiction. It was somewhat confusing for me. So I wanted to see if anyone has any comments on that approach. Judge Pekar?
Well, this is a delicate topic, the unity of jurisdiction, or different approaches to jurisdiction. When I was mentioning some time ago that what is more important at the current stage of the international community, of the history, is that prosecutions take place for international crimes rather than having a unity of jurisdiction, I was dealing with international courts, with this proliferation of international criminal courts.
But now you have a proliferation of domestic courts throughout the world, actually. How does it relate to the unity of jurisdiction as these domestic courts now are created?
Well, that's again a point. I think it's better than, again, I would say, is preferable that domestic courts around the world, in the world, deal with these matters, even if there is no unity of jurisdiction. Right. For the time being, than than waiting for a unity of jurisdiction and doing nothing in the meantime. We have to recognize that justice over international crimes, and without neglecting the experience of Nuremberg, of Tokyo, started 15 years ago. And inevitably, it's not structured yet, fully structured in the international community. There is an international criminal court which is starting, which may eventually be that structure. But again, I believe that court will have to deal with the domestic jurisdiction and perhaps try to ensure unity of jurisdiction. But for the time being, the only thing we can do probably as ICTY is to try to achieve a sort of unity of jurisdiction between the ICTY and the local jurisdictions in the region. I think that would be extremely important for the region itself if eventually cases are regarded back as being dealt more or less keeping a common standard, a common approach, be they tried before the ICTY or tried before the local courts. That's why the interaction.
Well, does that, let me ask then, Barbara, because is that part of this idea of supporting this unity of jurisdiction? We know that international courts have been moving and have for a long time in its creation towards a more adversarial procedure. And we're seeing that in many of the domestic war crimes courts that are emerging. Is that reason why the U.S. had pushed for this kind of common law adversarial approach in Bosnia, or was it for other reasons?
Well, I was not here at the time that that was done, and I'm not sure that I can respond that that was why the U.S. pushed for the change from the continental/civil jurisdiction to the common law jurisdiction. However, we do know that that is the system that's in place now, and based on looking at the laws and the structure of the courts in Bosnia and looking at the ICTY, I think there's no question but the fact that the ICTY served as a model not only for the courts but for the type of judicial system that was put in place there. For example, you have the international judges and prosecutors at the ICTY. In Bosnia, you have the international prosecutors and judges embedded with the local judges and prosecutors. And so, again, if you're talking about unity of jurisdiction, meaning that if a defendant who is tried for a war crimes case before the ICTY is going to have the same sort of jurisprudence before him at the Bosnian court, one would hope that that would be true, that the rule of law would apply.
But it's a fundamental jump to suggest that as part of the procedural approach that you're going to have mixed tribunals, you're going to have international judges, prosecutors' involvement, you're going to have this adversarial approach in what was a civil law system. That's a fairly fundamental a step that the international community, I think particularly the U.S., has made, and I wonder whether the consequences in the future will be somewhat mixed or even quite uncertain about this. Shelley, you had...
Yeah, no, I think you're right. I mean, I'm not going to go to a conclusion of what the result has been, and it's not my place, nor am I well positioned to say so. But I do think there has been reflection on 2 points that come up here. One is the international engagement in countries pushing models. And I think a lot of the reflection over the past 20 years of international engagement, many people now think that pushing particular models on countries is perhaps not the most effective way to engender nationally owned strategies and approaches for how to strengthen communities' understanding of strengthening the rule of law in their own context. So models aren't maybe helpful. Obviously, from a UN perspective, there are common standards. There are obligations that almost all member states have under international law, and that is the starting point for the UN with respect to when you're prosecuting crimes. Ultimately, the obligation lies in the first place with the national community to prosecute serious international crimes in their own jurisdictions. But that aside, there are also a number of norms and standards that are developed that are called soft law or developed in the context of the United Nations Crime Congress, developed in the human rights area, that are very useful guides and that are global guides that are developed by states themselves and by experts within states themselves that help to guide reform on criminal justice and other particular issues. Those are very much a part of a UN approach. But I think this idea that national societies should come in with their own models and push other societies to take those on has been seen to be in many places ineffective, because it actually has often been in part, different parts of the system. So you will have one national model pushing the police to go in a certain direction, and then you might have another national model working with the judiciary, and this has happened in quite a number of countries. And then there is a clash basically between how the police are understanding their role and the judiciary and the prosecution understanding their role.
But it is amazing to me that we continue to make these mistakes, the idea of lessons learned, assessments, and yet we keep repeating that. I want to turn it over to the audience here because we're running out of the time that I wanted to use for the panel. I have 2 quick questions for this panel before we turn it over. And one gets to the fundamental question about, well, what, in the sense of the legacy of the ICTY, what has that had, the impact has had in beyond the former Yugoslavia, in the sense of the creation of other courts? I did a little research this week, and I noted that there are 20 domestic war crimes courts or initiatives now underway. That would have been quite different 15 years ago. So this proliferation of courts and modalities to bring to justice individuals accused of these crimes has really risen. To what credit can we give the ICTY for this, again, proliferation of these domestic mechanisms of accountability? Judge Pokar?
Well, there could be many factors, actually, why the existence of the ICTY and the operation of the ICTY has fostered the creation of other international courts and of other domestic courts dealing with war crimes and crimes against humanity. One could simply say, well, the ICTY was the first one to be established, and inevitably the example has been followed because it was the first one. But I think there is more. The ICTY has shown, and it was the first time that that happened in the history, that international justice is possible, and that it is possible to bring about a fight against impunity through international criminal courts. I mean, the ICTY has been successful, although there have been many things that did not work, as obviously as is obvious when you start a new experience. But on the whole, if we look now after some years of operation of the ICTY, it was apparent, clear, that the tribunal did work and there was a possibility of exercising international justice. And this has accelerated, in my view, the creation of other international courts, including the ICC. Great. Because we should not forget that the project of an ICC started immediately after the Second World War and simply did not succeed. It was the fact that this tribunal and the Tribunal for Rwanda worked that accelerated the process for a permanent court. As to the domestic courts, again, I think it's a problem. This might even have been accelerated by the ICC itself, because under the principle of complementarity, the states would try to avoid to go that their nationals or for events occurring in the country be brought before an international court. They may prefer to have them dealt with in the domestic jurisdictions.
So not full credit for the ICTY.
So I give some credit also to the ICC.
Norman and then David, quickly, and then I'm going to ask my last question before we open it up.
Thank you, Mark. Just one quick point, which is that the impact of the tribunal in domestic prosecutions should also be understood in the, I wouldn't say proliferation, but certainly the increase in domestic prosecutions in countries other than the former Yugoslavia. We receive, in the Office of the Prosecutor, again, I'm only speaking of our office, we receive a number of requests from a number of countries who may not have either known about the crimes if there wasn't the ICTY, or may not have known about the prosecutions, or may not have known about the particular groups of people that may have been involved in it that they can investigate in their own jurisdiction. And therefore, when we speak of the legacy, though it's only a minor point, I think it's important to also keep in mind that there has been an increase in domestic prosecutions in countries other than the former Yugoslavia, which we have assisted in that sense in capacity building. David.
Yeah, and just to follow up on what Norm said, Bosnia and Herzegovina has actually assisted other countries that have immigrants, asylum seekers and others who have gone to those countries, and now because of the work that we